Hey guys, how y'all doing today?
Good.
Today. I don't even know what time it is. My name is Jared Miguez. I am an attorney at the Arena Collective. This is my partner, John Stevens, and one of our other partners, Tyler. Tyler's not an attorney. He just has the best looking beard up here, so we asked him to sit with us so we actually look a little bit older than we may look.
Next up.
John and I have been doing this for 6-7 years together. We met each other in college and kind of reconnected with back to the North Shore. And we really started piggybacking on our gifts and talents. And John, very analytical and smart and process oriented. I'm a little bit more of a
China shot.
Yeah, shoot from the hip kind of a guy. And when I first got into business, I fell in love with the investor community. I was in law school and I wanted to learn how to invest in real estate. And I figured the best way for me to do that was to apply my law degree to the real estate industry by getting into title. And I wanted to do the most difficult transactions. A lot of title companies you work with handle the residential first mortgages and refinances, and they're really good at it. And they just don't enjoy the more complicated transactions. There's not as much juice in the fruit as a regular deal sometimes, and sometimes there's more. And you got to kind of search for it, and you got to build processes, and you got to work really hard to help the real estate investor community accomplish the goals they want to accomplish. And the reason why I say you got to work really hard is because y'all's dynamics are always changing. 5 years ago when I got into business, there was this big thing called wholesaling. I don't know if you've heard of it, but everybody was freaking out about it, right? The real estate and agents were, these people are coming in and acting like agents. They just don't have any of the rules, and everybody didn't know what it was, and it was going to do away with the real estate industry, and they wanted to put it into it, right? Now there's real estate agents that specialize in wholesaling and real estate agency, right? And so we built a process around wholesaling, and it was fun, and we became the title company that everybody knew in the investor world that was interested in helping real estate investors with wholesaling. And now it's kind of merged or transitioned into seller financing. And so we get questions about creative seller financing deals every single day. How many people have been presented with an opportunity or have tried to get into a seller finance deal? Raise your hand. Okay. How many people have no idea what seller financing is? Raise your hand. Okay, well, everybody's familiar, so I can start from the end.
Leave.
Yeah. And so we really set out over the last couple of months and really about a year and a half now to build a process around seller financing. And so what we wanted to do today, and we were covering for Will Frederick, who's going to be a great presentation when y'all get him in here. I think he's going to present next month. I called him today. He wanted me to tell y'all sorry he couldn't come. He put his family first, which I respect the heck out of that. He'll be here next month. But what I want to do today is open the floor to you guys to ask us any questions about seller financing that y'all may have. And we're going to kind of talk a little bit about seller financing to you guys. Tyler's bought a couple properties seller financing, right? And so he thinks he's just sit here quietly and sit next to me, my comfort leg here, but we'll watch it. Yeah, but he can chime in if he needs to, because we've handled a couple bond for deeds for Tyler that have actually canceled and found a new client, and he can tell some stories about that. But so the first thing I want to talk about today is the difference between a credit sale and a bond for deed. Can anybody volunteer to kind of give a suggestion or an idea about what a bond for deed actually is? Anybody want to take a swing at it?
Or maybe a better way to ask it, what's one of the most fundamental differences between the two?
When title transfers.
When title transfers.
Oh, where's my book?
Yeah. I didn't bring a book to give you.
Yeah, shoot.
It sucked. We didn't bring cards or books, but Will's going to bring all that next week. I'll make sure he brings next month. So the main fundamental difference between a bond for deed and a credit sale is when title transfers to the buyer. Okay? So on a bond for deed, the way those are typically structured is the seller retains ownership of the property up until the buyer pays off the agreed upon purchase price. So usually what it looks like is that the buyer is going to put some money down, traditionally. The seller is going to finance the rest of that over a period of time. A lot of times it's amortized over a long period of time, and there's a balloon feature in there, meaning it's going to be paid off at some point at an amortization schedule that's before the end of the full amortization schedule. And like she said, the real kicker and the trick is that the title doesn't transfer up until that last payment is made, that loan is paid off. Okay? And depending on what side of the transaction you're on and how the dynamics play out will depend on whether you want to structure your deal as a bond for deed or a credit sale. And so,
And depending on which party you are in the transaction too. Yes.
yeah. So real estate agents will call me and they'll get an offer from somebody offering bond for deed, and it's one of their listings that they have. And a lot of them don't know what a bond for deed is, or they haven't worked a bond for deed transaction, so I have to kind of coach them through that. And a lot of times they don't know whether they should use a credit sale or a bond for deed. My advice, generally, not knowing all of the ins and outs of the transaction, is that if you're representing a seller or you are a seller in a transaction, that a bond for deed is going to be the best strategy for you. Okay? And there's a lot of reasons why. A couple of them is that in any real estate transaction, you want to have control of the asset, or as much control as you can, right? And so on a bond for deed, because you own that property, you have more control over it than you would if you actually sold it to them and gave title to them. And the real benefit to that is in the case of default. And so when a buyer defaults on paying back their bond for deed, the remedy for that for the seller, they still own the property, still have title. So they've got to send notice to the buyer they're in default, wait the requisite time period, which is 45 days. That's why I've done here. After that 45 days, that seller can go to the courthouse and cancel their bond for deed. And they retain the ownership in that, and they can then go and do another bond for deed if they want to. They can list it on the MLS. They still have control over that, which is the opposite remedy, which happens in foreclosure on credit sale, which we'll talk about that in just a second. So what you got, buddy?
So is that just a cancellation of contract in foreclosure? You don't have anything official?
So yes, it's outside judicial. You have to give the 45-day notice. You have to provide proof and attach with your cancellation the proof that you had sent it, right, and proof of delivery, and then therefore proof that the 45 days passed since the filing. And some people say, well, can we make it less than 45 days? The law says that any stated time that's lower than 45, right? So if I have a bond for deed contract that says we're going to do 30 days instead of 45, can't do it. Automatically goes back up to 45. You can go over 45, right? But can't stipulate to lower.
And so your seller in that scenario, which just happens relatively often, the buyer will put down a little bit of money up front. It'll be fine. The rest of the purchase price will be financed over time. If that buyer defaults, the baseline basic rule is that seller gets to keep the money that the buyer put down and any interest in any principal that was paid, and then they can start the bond for deed process over with a new buyer. And so that is a very big benefit for a seller to make sure you structure your deal as a bond for deed. Now, there are some caveats to that. If the buyer puts down 50% equity in the property up front, and then shortly after that defaults on the bond for deed, and the seller goes and cancels the bond for deed, if they got into a lawsuit, a judge is probably going to say it's a little bit inequitable for that seller to walk away with such a large amount of the equity in that property and not have to give a little bit of that back to the buyer. But
you have to justify that, with effectively say, hey, this is tantamount to rent that I could have got a fair market rent, right? Costs of administration. And basically how we design ours is we keep an eye on case law that interprets the bond for deed statutes and then pull anything new that we see that justified the seller's ability to hold that money. We'll just throw it into the contract. And typically one of the easiest ways to point at it, though, is it's essentially the fair market rent.
Yeah.
Right. But like you said, 50%, if I'm bond for deeding something to him for 150 and you give me 75 and 45 days later I cancel it, that's not fair market rent. And not, at least not down here, maybe in New York or something, city.
so that's a bond for deed. Anybody have any questions about a bond for deed? Oh, that's exciting stuff. What you got, buddy?
So if they do default after getting 50% down, what's the ring of it?
I mean, at that point, you're probably safest thing to do. I mean, you can just keep it and see what happens, right? Or, I mean, it might be prudent to say, well, look, let's figure out what would be fair. It might be one of those things to say, well, I'll give you X amount just to mutually cancel it, right? In which case you can, in that mutual cancellation, release any and all claims, right, that might arise out of that contract, right? So, otherwise, if you keep it, you never know. They might be able to just come back and, I don't know what statute of limitation. It might be a 5-year on that. similar to notes. Yeah. So I mean, like, you could be kind of an extended period of time that you're waiting to see if this person going to come after us more money, right? So maybe nip it in the butt on the front end and offer, dangle a carrot, get a mutual cancellation.
And so, you have a question?
Yes. How often, in your experience, have people you've given up the bond for deed?
Defaulted?
Roughly.
How many bond for deeds have you done?
So only, 3 or 4, I guess.
How many have canceled?
Well, once we close.
Yeah, that's good. Yeah. I mean, I would say since we started doing them in probably 19, probably, a dozen. They're about, and that's just us doing them, right? I mean, in our office might have been more. It tends to be probably maybe, not all the time, but maybe a lower value property where they put a little bit down and then just go AWOL, and you can't find them hardly. And their circumstances kind of suggest that they could care less, but
I've actually strategized with one wholesaler who started using bond for deed instead of doing wholesaling, where he obligated himself under the bond for deed to pay interest only for a certain amount of time, and the balloon growth in 6 months or so. So he was pretty much buying his ability to find a buyer for that, and it was a better way for him to market himself than a traditional wholesaler who just gets you under contract and the seller to kind of shoot in the dark, hoping that you're going to have the pool of buyers. This guy was vested in it, and he would go with people and say, "Look, I'll bond for deed this from you for 6 months, interest only at a low rate. So I have the opportunity over the 6 months maybe to put some money into it. He can take the increased value of it if he puts some money in it, that value improved, or if he could flip it and find a new buyer, more money, he could make a spread on it." So it kind of depended on the dynamics, but it's a way for a wholesaler in some instances to market themselves a little better than traditional wholesalers, especially on a very favorable property that a wholesaler are trying to get.
But the agreement between the parties can be, it's very tailored. You can do it either way.
Oh yeah.
Yes, well, this can be structured in very similar, and that's why when I say a lot of these things, I'm saying traditionally, or the basic rule is because a lot of these things can be negotiated, right? And we talk about bond for deeds and credit sales as seller financing tools, but then you also have a lease purchase, which is kind of a third leg out there, which is similar. It can be structured very similar to a bond for deed, where most lease purchases are set up where the tenant, is what you are as a tenant, is paying every month just to lease the property with the option to buy it at a certain point. Well, generally those lease payments aren't applied to the purchase price, but sometimes we will tailor a lease purchase similar to a bond for deed. We will say a portion of the lease amount is going towards the purchase price every month with the option to buy the property. Well, if you don't exercise that option, you lose that credit, but you're pretty much buying yourself the option at that point to buy the property. So it's kind of a mix between lease purchase and a bond for deed when you have some of that lease payment going towards principal. And Kel, go ahead.
Well, I was going to say, we get the question a lot, like, what's the difference between why don't I just do a lease option? Because on its face, and a lot of the dynamics are very similar. A bond for deed, though, kind of handcuffs a little bit more, right, on the buyer, so to speak, which is say, look, they're contractually bound to perform, right? On the option, it's just an option. You don't know if they're going to exercise that option. And maybe if you want to get out from underneath the property, you don't want to manage it, whatever the case might be, you're more locked into a buyer through a bond for deed than a lease option. And not to say that that's, always exactly what you want, but that's a question we get often, which is what the heck is the difference? They seem like the exact same thing, and they are similar in a lot of ways, but that's one of the, there's a little bit more gravity to it with a lot of these.
Another big thing is attracting a home buyer, not a renter.
At least, totally. You're right. At least laws are, look, the default lessor law, laws that say, hey, lessor, you tend to, then there are, we know, right, there are programs that advocate for tenants, right, in the state. There are not necessarily programs that advocate for buyers under bond for deed, right? So it might be less of a set of teeth that you walk into. Yeah.
So you just
that's it. Look at that. There's a lot of wisdom in those gray hairs. Isn't that cool?
And again, just to finish up on the lease purchase deal, from a seller standpoint, you're a landlord at that point, and the default lease laws require certain maintenance and repairs to be made by a landlord for a property. So unless you negotiate those terms in that lease purchase, you could be under a lease purchase, which seems like you would put a little more money in your pocket as a seller because that tenant's paying you money every month. You put all that in your pocket. It's not applied towards the principal, but you're also stuck with some things that you're not necessarily stuck with under a bond for deed. Under a bond for deed, that buyer takes possession and they're responsible for all the traditional maintenance and repairs of that property totally separate apart from what a landlord would be required to do under lease option. So that kind of the nuance between the two. What you got with the backs?
How much is the payment is going for stencil on the bond rate?
It just depends on how you structure the terms, right? I mean, like if I've got $100,000 at 5% on a 30-year amortization, you just run that amortization schedule and it works for you. So, some people will do simple interest. You know, that's purely negotiable between the parties. Yeah, and like Jared said, I mean, we have a lot of them, and they're shorter terms, but where it's interest only. You know, some people do interest only for a year, 6 months to a year. You're probably on the higher end or longer end. But that's purely what the appetite of the parties are with respect to how they negotiate it.
Yeah. And like, if you think about it, generally speaking, if you're going to go borrow money from a bank right now, you're going to be paying on an investment deal, you're going to be paying 8, 9, 10, 11%, right? And especially on short-term financing. So, on these seller finance deals, people ask us what our opinion is. It's really, if you think about it from a basic standpoint, the interest rate that a bank charges you is just their charge for the risk that they're giving you the money for, right? So if they're giving you money and the risk is low, they're going to have a lower rate on that. If they lend you money and the risk is a little high, they're going to charge you more. From a basic standpoint, the reason why you pay more when you buy investment property than when you buy your primary residence is because if shit hits the fan and you have one bill you got to choose to pay, you're going to choose the one that has the roof on top of your head, not necessarily the one that puts the roof over somebody else's head. I love John, but I'd rather have my girls protected. His hair is nice, but I mean,
I'm not one.
Yeah. But I was talking about that.
Okay.
I was
Okay. Yeah. We both.
You got both of you got
That's nice hair.
So that's why they charge more. So like from your standpoint, if you're a seller and you're selling property to somebody, it's not their primary residence, especially an investor, you can feel a little bit feel comfortable charging the money that you should charge for. And also on top of that, again, assessment of risk. A bank's got hundreds of loans out there, so they have a diversified portfolio. They can lower the rate a little bit based on that portfolio. If you're a person who's got one rental property and you sell that to somebody bond for deed, your risk of loss in that scenario and your investment you've made is higher. So charge a higher amount for somebody who's going to be getting the benefit of not having to go to a bank and pull a credit, go through all the hoops for that. So it kind of depends.
And you might be wary on that point of like doing a 30-year term on bond for deed, right? I mean, like let I don't remember who I was talking to today about it, but 5 to 10 maybe the most, right? Because again, that goes back to the risk thing you talked about. You might not want to be in it for a long haul, right? It can be more of a stopgap for these people to maybe eventually refinance out of it. So you want to put an end to that term that's not too far down the road.
Yeah. And to be clear on that, thinking about it, the term that he's talking about is the term in which it's going to balloon.
Yeah.
As opposed to the term in which it's amortized, right? The amortization term is what's going to dictate how much they're paying, and really, because the longer the amortized term, the lower the payment, right? If you got to pay $100,000 over 5 years, $100,000 over 30 years, you're going to pay less per month over 30 years, right? But the balloon term is at what point in that amortization schedule that the entire amount is due. So let's say 10 years in, $100,000 loan, $70,000 left, and you want to be paid off at that point. Well, at that point, they've got to come up with $70,000 cash to sell it or refinancing that to a traditional loan. What you got, buddy?
In regards to risk, the difference between a credit seal, a bond for deed, the risk on the seller as an insurance risk for somebody gets injured on the property, is there a difference there?
We know we're in a litigious state, so everybody's going to get roped into it at the end of the day.
Yeah, I mean, honestly, it's a shotgun blast approach. Just who's going to get pulled in if there is any type of litigation. I don't think that you're mitigating risk one way or the other. You're both going to have insurance provisions requiring that the seller in a bond for deed be an insured, right? Or under credit sale, a lost payee. You can get kind of granular with how the payouts might work on claims. I guess that's a hazard claim, but with respect to like having someone come after you, right? Mm-hmm. You just want to make sure that insurance provision properly articulates the requirements of the insurance, the capacities of the insured, general loss payees. Some insurance companies aren't super familiar, or agents aren't necessarily super familiar with the dynamics of these types of things anyway, particularly the bond for deed. So you kind of have to coach them through it, and you might not be able to get and we've seen this, an additional insured on our property, they tend to always say, well, you got to get renter's insurance, right? It's not really the same thing. It's not as good of a coverage, right? You want to talk to somebody who can kind of understand dynamics and say, okay, this person has a financial investor, right? There's a risk of loss of financial, I can't remember the exact terminology, but the definition of what renters you're capable of paying insured, right? Either as an additional insured or a loss payee. So, but in either context, you just want to make sure that the insurance provisions are in place so that it's kind of apples to apples.
I mean, it's that dog bite risk that always scares me.
Yeah.
You know, it's I've heard firsthand accounts of people losing $400,000 or $500,000 due to their tenant's dog biting somebody.
You know what? I mean, not just honestly though. I mean, if you credit sale it and you're just a loss payee as a creditor, I mean, you know.
I had a guy the other day call, and we structured a deal he was on the seller side as a credit sale because of that fact.
Yeah, you're right. You're right.
More worried about the risk of owning that property, even though he had sold the rights to purchase it to somebody else.
Yeah.
And he structured it as a credit sale for that one reason.
Which is interesting. That's a great question, because I know you're going to get to this. But then you have to balance that with the recourse you have as a creditor and how hard it is to make yourself whole, right?
Yeah.
Yeah.
What are you more afraid of, the dog bite or reclaiming the property?
Right. Yeah, exactly. Yeah, you're right.
Cool.
Right.
Yeah.
See, have we crossed 20 minutes yet?
Yeah.
Okay, good. I was worried we were 20 minutes, but okay, we're good. We made it this far, guys.
That's a good question.
Yeah, that was a very good question. Okay, so any more questions about bond for D before we move over to the other side of the fence? What you got?
Do you, since bond for D title is not transferred, do you still do tower
Oh, yeah.
for both?
We do, and we've kind of got, we went back and forth on whether you could get a title insurance policy as a bond for deed buyer.
You can get one.
You can, but it's not going to do anything for you.
Yeah.
We take your charity if you want, but you should probably keep your money and wait.
Yeah.
The key is that the title insurance companies are going to have the policy kick in once you become the full owner of the property. So, you know, you might as well keep your money and wait and buy your policy when you pay off the loan or pay off the debt and you owe it 100%. So, but we will do a title search and we will let you know what the condition of title is before you buy it. Obviously, we're not insuring that position because we can't, but we will let you know what the status of title is before you buy it. And that will get to the kind of layered approach to this when we talk to 72 financing and when it relates to property sale. We'll talk about that in a second, but we deal with that a lot.
You had a question too, man.
Just real quick, can you sell a bond for D like you can sell a note?
Sure.
You can assign your interest under it. Most of the bond for deeds will say that. Oh, you mean if you're the seller or you're the buyer?
You'll be the seller.
If you're the seller, I mean, so the bond for deed creates a special mortgage in favor of the buyer. Okay. Which is kind of conceptually strange to hear, but it does. It creates a special type mortgage that says, hey, this buyer's protected in the equity that they've built. So if you then go sell it, right, the person who's buying it from the seller under the bond for deed, right, so from the vested owner, they're going to have to understand that, A, if they're trying to get lending to buy it, that lender's going to be subordinate to that special mortgage, right? So that might be difficult unless you have our money or unless the bond for deed guy decide, agrees to subordinate. And if he has cash, that's fine. And, I mean, as I would say, though, more than likely you wouldn't be able to alienate without, I would think, consent from the bond for deed buyer, right? Because they're privy to that contract. So you would have to get effectively a modification to the bond for deed anyway, right? And the safest route to be would just do an amendment and then assign basically the seller's interest. But yeah, you could. Yeah, that is an interesting question.
As far as the investor and buying and selling stuff on financing, what's most favorable? Lease option, bond for deed. When you're selling and buying,
So we'll get into, let's get into credit sale then.
Yeah.
Because generally speaking, if it's assessment of risk, right? As a seller, are you worried about the dog bite? Are you more interested in having control over the asset? All that stuff you got to determine. That same with the interest rates, like she asked earlier. All of that is an assessment of risk on what you want to charge. On the credit sale side, which is the seller acting like a more traditional bank, where the seller is going to sell the property to the buyer at the day of closing. We're going to draft a cash deed and we're going to actually give the property to the buyer. Our cash deed is also going to give the seller a mortgage that's going to state that they have a security interest in that property up until that buyer pays them off. And that buyer is going to sign a promissory note And that promissory note's going to have, it could be the exact same terms as the bond for deed we were talking about, just flipped over to the credit sale, where the buyer's going to pay the seller over time. Now, as opposed to a bond for deed, because the seller transferred title over to the buyer immediately, the only remedy in that scenario is a foreclosure like a traditional bank. Typically, the remedy is a foreclosure. And most people don't realize, all you guys are sophisticated real estate investors, so y'all know this, and I can tell you that you don't know. At a foreclosure, you ask the sheriff to seize that property. The sheriff's going to say, I'm going to seize this, and I'm going to put it on the auction block. And everybody in this room goes to the auction block whenever they have it on that Wednesday of every month, and y'all are going to bid on that property. And you're going to pay the sheriff. The highest bidder is going to pay the sheriff. That sheriff's going to say, thank you, I got to take the money, and they're going to pay that seller off. So now the seller's made whole, and there's a new buyer that owns that property now, right? So you as a seller in that scenario, your only remedy is to foreclose and get that property back. That foreclosure period can take a long time. We talked about on a bond for deed that it's just 45-day notice unless otherwise stipulated, and then you file a cancellation and you take the property back, take possession back. You might have to evict somebody, go down that rabbit hole on a bond for deed, but on a credit sale, all you're going to do is get that money back, and it's going to take at least 90 to 120 days to go through the whole foreclosure process. And it tends to cost more money, and it's just a more difficult process to recoup your investment in that deal under a credit sale.
And the question always comes, I hear at least probably once a week, can we just execute a deed in lieu at closing, where dash on is how we call it, dash on?
Is that Latin?
In Louisiana.
French, whatever.
Like spell it.
DATION, dash on, ENPAIMENT. All right. Anyway,
Same thing.
you cannot. Absolutely an invalid document. If I credit sale Jared a piece of property and say, hey, listen, buddy, I don't want to have to go through that foreclosure stuff, so we're going to sign this document where you're transferring it back to me, and if you default, I'm going to file this, I'm going to get the property back. Louisiana law expressly prohibits that. It can be done in other states, and I think that's why a lot of people always ask, right? Yeah. But the execution of that type of contract, which is to say that it satisfies a debt, right? Because that's what it does. It satisfies and cancels a debt prior to the default. Execution of that contract prior to the default and the acceleration of sums due is patently prohibited. It's invalid, right? So, we get it all the time. We get that question, and it frustrates the heck out of people to hear it. But even if you do execute it, I'll tell you, sure, if it makes you feel better, fine. But that buyer's going to be able to say, oh, look at the date on this. Or where were you on whatever date at this time, right? And where did you sign that? Or who were the witnesses, right? I mean, it's not going to be effective. So that when he says, as a creditor, your recourse is foreclosure, that's the automatic one. That's not to say that you can't do a dash on, right? But only if only if your buyer under the credit sale agrees to do that to cancel the debt. And you're probably not going to get that if it's been, much time where they've built equity into that property, because that foreclosure, like Jared was saying earlier, let's say I've got a $150,000 balance and it's a $200,000 piece of property, and they've built some equity into it. Well, I'm going to get my 150. The sheriff's going to get their piece, right? Because they always do. And then the buyer is going to get the equity that they built in.
At 50 grand. Does that make sense? So at the sheriff's sale, if the debt's worth 150, they collect 200 from the public auction. The seller's only going to get the 150 they're owed. The buyer's going to get whatever's left from that sheriff's sale. So they may get a little money on that deal. So that's why they may not be interested in giving you the property to exchange to cancel the debt. They may have built up enough equity. They want to get that out at least from somewhere, from the sheriff's sale. And we have, on a kind of a different note, when it comes to the foreclosure process, we have helped people stop short sales, and help people avoid foreclosure. And a lot of times we do that when real estate investors in this community. Gabriella Francescan's talking at the West Bank next week or this week, maybe that was Thursday. Gabriella's a good friend and a great client of ours. She does a lot of subject to purchases, and she's made a lot of money on those deals by being creative with them. And she will stop foreclosures through credit sale, seller financing. And so if you want to pick anybody's brain about practically doing that, she's a good person to talk to about it. Because so anybody have any questions about credit sales? A little bit more simple than, say it again?
Who is that? You
Gabriella Francescon. She's talking at Aussie Steve's West Bank meetup this week, and she's a really good real estate agent. She's a real estate agent, real estate investor, and her husband have some properties that they manage too. So we talked about bond for deed credit sales. A layer below that, a really sophisticated investor may structure either one of those types of transactions as a subject to wraparound mortgage. Anybody heard of Pace Morby? Anybody have Pace Morby's group? Yeah, in the back, you are? Okay. We've got a lot of contracts from people across the country that are sending offers to real estate agents or that properties that are listed, trying to buy the property subject to from Pace Morby's program. And we know that because his contracts are very standard. They're not great contracts in our opinion. And so we've actually helped people rewrite those to terms in Louisiana.
Give what it's worth, and it's a credit. There is some good stuff in there, but it could be cleaned up.
It can be cleaned up for sure.
Particularly Louisiana.
Yeah. And so, does anybody know what wraparound mortgages are subject to transactions? No? You know what that is? Okay. Anybody interested in that before I go down that rabbit hole? All right. I'm talking. Nobody's really given a ton of feedback.
I want to hear, because we'll get into what we've started doing as kind of the next level of how to structure it. But yeah.
So just know that those two tools we talked about, bond for deeds and credit sales, are great tools whenever you're a real estate investor and you want to maybe get into some properties that you can fix up and flip and have really good, strong offers by putting some money down and being a credit sale buyer, or maybe even giving an opportunity to somebody as a bond for deeds seller. So they're a good tool to use. In any scenario, either one of those scenarios, you could do a wraparound mortgage or a subject to financing. What that means is that you're going to, as a buyer, agree with the seller to buy the property on a credit sale or to bond for deed with the ability to buy it by paying their creditor on their behalf for a certain amount of time. So hear me out on this. Let's say that John's got a mortgage with Wells Fargo and he's paying 3%. Okay. And I want to buy John's property. That if I go borrow money from a bank, I'm going to be paying 10-11%. And the property's worth $200,000 and John only owes $100 on it. I may give John $100,000 so he gets his equity, and in my, let's say, credit sale documents, I'm going to tell John to give you $100,000 down, but then I'm going to finance the other $100,000 by paying your creditor on your behalf. So what John's done is he effectively walks away with his equity, and then I get the opportunity to pay or pretty much finance the transaction on John's terms and pay his 3% loan through the duration of how much longer he has on his amortization schedule.
And as a quick disclaimer, it's not a formal assumption of the loan, right? Because
we don't have to apply for it.
You don't. No. So, and that's kind of Pace Morby's stick, right? You can buy a whole bunch of properties without having to use your credit to do it. You use the seller's credit to do it, and you do that by literally using the seller's credit and financing the loan by paying them off so they walk away with their equity, maybe a little bit more than their equity's worth, but getting that interest rate at such a discount that it makes sense. And
you can even seller finance on a carryback. You can do a carryback note on my equity. So in that same situation, I have $100,000 in equity. He might give me 20 down, right? And then execute a note that he's going to pay me the other 80 over X amount of time,
and also pay it.
Yeah.
And so you can get as nuanced with that as you want, but it's very important to understand that there's two relationships in that scenario, right? There's a relationship between John and his creditor. Him and Wells Fargo have that obligation where he has signed a note mortgage saying he's going to pay at Wells Fargo over a certain amount of time. And then there's a totally separate agreement between me and John that I'm going to give him that $100,000 down, and then I'm going to start paying his creditor on his behalf. So the critical thing to know there is that John has to pay attention. He can't just walk away and assume that everything's great because he got his equity. He has to pay attention to make sure that I continue to pay his mortgage for him, because if I stop, it's his credit that's on the line. And so for that reason, a lot of times if John's got 10, 15 years left on his loan, he'll require a balloon payment in a certain number of years so that he's not floating out there with a Wells Fargo mortgage for 15 years that he doesn't, that I pay off. And so a lot of times we'll structure those on a balloon term that's 1, 2, 3, 4, 5 years at the longest, in my opinion, just because you don't want that attached to you. Now, how this can be applied in y'all's business is that if you have somebody, this is a real scenario. This kid was 25 years old or so, bought a house when he was younger. He had two buddies living with him. They both moved out. So he was by himself. He quit paying the mortgage. His dad and his brother-in-law found out. and brother-in-law said, "Look, you're going to foreclose, and your credit's going to go to shit, and you're going to have a hard time." I say these three things: you're going to have a hard time finding a job because if you work for a bank or a government entity, they're going to look to see if you have a foreclosure in your record, and you might not be able to get a job that you want. The second thing is that you aren't able to buy a house for at least 2 years, maybe 5, depending on the dynamics of everything. And the third thing is you may even have a hard time leasing a house because they might pull your credit if they're a good landlord. So to avoid those three things happening to you, what I'm going to do is I'm going to buy the property subject to your mortgage. I'm going to pay to get your loan back current. And in this scenario, he didn't give that kid any other money. He said, I'm going to get you out of this situation by paying your loan current. It was a couple of $10,000 bucks. And he said, I'm going to start paying your mortgage on your behalf. And what that did for his brother-in-law, this guy who was paying the mortgage, was that his brother-in-law got to go find a house, move in with mom and dad, whatever that kid did. And he started paying his brother-in-law's mortgage for him, which looked as though, again, from that relationship between that guy who borrowed the money in his bank, that he was making that payment. So that kid's credit was getting better while his family member was paying his mortgage for him. So as an investor, if you really want a value add, in my opinion, it's when you're talking to these foreclosed buyers, you talk to them and say, look, I can help you in this situation. I can help. If you go through foreclosure, you're going to be in a way worse situation than you would be if you just let me get you in a better position. I'll pay your loan current. I'll start making your payments for you. I'll build your credit back up, and I'll give you a 2-year time frame in which I'll start me paying. In that 2 years, I'm agreeable to balloon this payment. So it gives you 2 years of me helping you build up your credit. You can get in a better situation. Hopefully, at that point, you're in a position where you can buy another house. And so we help people do that all the time. Literally did it on Friday, where we did a credit sale, wraparound mortgage. When a guy was going through foreclosure, we got the short sale payoff. We were able to negotiate a few things with the bank. We brought the loan back current, and now this buyer is starting to pay this loan on this guy's behalf, and he's going to be able to move on with his life and not have this foreclosure on his record. And so that's kind of how it ties it all together right now. What we're seeing a lot is, and you could do that through a bond for your door credit sale with the subject to financing, and a lot of people are using that as real estate investors to meet foreclosed buyers and help them get out of shitty situations. That all make sense?
So you can have that with title transferring or without title transferring?
Yep.
What are the pros and cons of that?
I mean, if you're a buyer, again, looking at the situation and knowing that the seller's in a distressed situation, they don't really have a ton of options. You have a stronger hand in negotiating. Usually, as a buyer, you're going to negotiate a credit sale.
Yeah. Well, real quick, too, because so if if you're buying a piece of property from somebody, and this is not a stereotype, or I mean, but just from a business perspective, who might be going through foreclosure, about to go into foreclosure because they can't pay their note. If you buy it under a bond for deed, right, you don't want to risk them accumulating other debts that might turn into judgments, right? Now, granted, your bond for deed does state that the seller's not supposed to allow for any other additional liens, and to the extent they do, again, they are supported to that special mortgage, but nonetheless, they might still, and would still attach to the property, right? So you could avoid some headaches as the buyer in that situation.
You always hear subject to mortgages, but can you assume any other type of debt? What if there's tax liens or something on a property?
You can. Yeah. Anything that's attached to that property, if you will do it. Now, on those, I mean, like, you're not paying unless there's a payment plan to the IRS. I mean, that's just, the bell will toll for that someday, right?
So can you clarify, assume, or subject to, you're talking about tax liens or other debts?
So,
Talking about assume?
In really no scenario we're talking about was anybody formally assuming any debt.
just taking it, I'm cognizant that these liens affect this property and I'm going to buy it anyway.
Which is why we do a title search, right? Because if you're buying a property subject to, I've seen it happen so many times where you go, an investor goes meets with a seller who's going through foreclosure. I got this mortgage, and this is what I owe, and this is my statement, right? And we get that statement, and everybody wants to go fast, right? 2-week turnaround. We start rolling our abstracts come back in about 3 to 5 days. We see the abstract, judgment, second mortgage in favor of HUD, and the buyer and the buyer's like, I mean, I can't pay off all these debts and pay a second mortgage in favor of HUD. It just, so you know, there's a lot of ways to remedy that, which you should never go into a situation where you're meeting with a seller that's going through that kind of situation and not ask your title company to do a title search. It doesn't make any sense to walk in there, spend all your time negotiating, explaining all this stuff to people without knowing what the condition of title is. And I'll say that so I'm blue in the face, and I'll have 0 people reach out to me and ask me to do a pre-screen, which makes no sense to me. but we have abstractors in-house, and unless you abuse the system and you send us 15 properties and don't close on anything, we're happy to do a pre-screen because all it's going to do is jump this line for us. We'll get that file or to be ahead of the game.
We've also built out some stuff that some formulaic underwriting tools that if we have a little bit of nominal information from like a mortgage statement, we can derive some additional data from the record on the mortgage itself, and then we can generate a lot of underwriting data that will allow you as an investor to be able to more quickly price numbers. That was what typically has people beat their head against school.
Somebody would probably have paid a couple $100,000 for the spreadsheet that John put together over a week, and he went in a rabbit hole for a couple of days when his kids were out of town and came out with like this spreadsheet that could literally, solve, cure cancer.
Yeah, well, yes, yeah. Fortunately, no. But I mean, so the idea though is if you look at it enough, this goes back to the pre-screen thing. Yeah, I mean, like build tools. We want to build tools and offer tools that can make you more efficient so that you can make your decisions more quickly and not by yourself wasting your own time, right?
Anybody's time, honestly. Our time, your time, the seller's time, all those things. So I failed to listen at Cole asked me to bring cards. I didn't bring any cards, but I'll put my information up there, John's information up there. And if y'all have any questions about it, y'all can definitely reach out. If you have a pre-screen, all we need is an address, and I'll run a pre-screen on it, send you the status of title so you know what you're getting yourself into before you show up. What you got, buddy? You had a question?
Yes, so subject to mortgage, you're the buyer. Why wouldn't you want to have that very fully balloon as long as possible?
You would. You as a buyer, for sure, you would. Yeah.
I've seen it where there's no balloon term.
Yeah.
And that's obviously greatly in favor of the buyer. That's a little bit unfair, in my opinion, to the seller, because that seller at some point in time over the next 30 years is going to want to buy another house, and their debt to income ratios are going to show this debt on their credit. So, I mean,
Now, is there a form that things can see that is being serviced by another parties?
they say that exists. I haven't seen that come to reality. I know that people say that you can, maybe you can't. I mean, because I know that if you're living in a property as your primary residence, 10 years later you move to another town, you can lease that property out, and there's no issues under your mortgage to do that. And I think that if you go to your next creditor and you show them that you've been collecting lease payments, you got a valid contract on it, that they'll consider that when they're considering debt to income ratios. But again, 6 months to a year a season, probably, I would imagine. And from 30 years having a loan outstanding, it just seems to me as a real estate investor community, we're here to solve problems for people and not necessarily take advantage of people. And so just thinking about it in that light, somebody who's in a situation that you've tried to help them get out of, don't cause a different problem by extending a mortgage for 30 years that they're not going to be able to get out of because, you want to take advantage of.
No,
That's just my opinion, but it's a good question.
Let's say you buy something sub 2 with judgments on it, so title transfers. What's the likelihood those can be either negotiated or they drop off? What does that look like?
I mean, look, if we see a judgment, we will typically always reach out to try to negotiate it. Like, what will you take for a partial release? You might not take a full cancellation. If we give you 5 out of the 15 they owe, right? Will you partially release this property from that judgment? Some will say kick rocks, and some will say, yeah, our client will be happy to get anything because we might not expect it. But in some instances, we tell people a lot, the judgment's worth the paper that it's written on, unless there's something enforced that it can be enforceable against. And so, we've built buddies, and we've made some buddies at a lot of those creditor law firms that would be like, I get a call, my client say they get $5,000. Yeah, okay. I'll grease that wheel for you a little bit. Some of them that will be kind of unempathetic towards it and say, I paid the full thing, but it just depends on the creditor. Any questions so far? Because I do want to touch on a couple things.
I just want to see if you guys were talking about do on sale clause at all. They got into it.
All right. So this is a fundamental aspect and the truth about subject to deals. Every mortgage is I'm gonna say every mortgage. Don't presume that one will ever be an exception. Says if you transfer your rights in the property, right, you have to pay this thing off. All right. And if you sell it, all right, you have to pay this off. If you refinance, you have to pay this off. Okay. A bond for deed, they've updated their terms. That is tantamount to having sold it. right? Which can be in some weird ways advantageous if you're looking at it from like a 1031 perspective. But nonetheless, if you do anything where you alienate your rights to this property, right, it could trigger a due on sale clause. Now, I work for D. Moore's. They're the biggest foreclosure firm in the state. I worked for them for several years. I've never once did I have to go to court. And I went to court a lot. Never once, it wasn't enjoyable. But it's, anyway, depending on where you're at. But not once did we foreclose on somebody because they were still paying their note, or the note was still getting paid, but they had transferred title, right, or alienated their interest.
So to say one real quick, a similar trigger effect could be if you transfer your property from your personal name to an LLC.
Right.
And again, we're talking about risk here from a real estate investor standpoint.
Yeah.
Is the risk of keeping the property in your personal name in that scenario outweighing the protection you get from an LLC for your personal assets? And so you as a real estate investor assess that risk.
Yeah. Now on that situation, I mean, it's easier when you're both parties. You can pop it back into your name real quick, but nonetheless, that's a very good illustration.
So now getting into this scenario, is as an investor, is this an assessment of risk?
Right. And so you have to approach it understandably. What happens if they do trigger that? I have heard, and I have no confirmable evidence necessarily, but we've had some people from out of state reach out to us, and we've had these conversations, and kind of go through all the, and you can tell people know what they're talking about to some degree, and therefore you can kind of rely on maybe what they're saying to be, there's some teeth to it. And they say, well, on the West Coast, they've heard of a couple banks getting stiffy about some things. So it's all about red flags and hiding red flags, right? Or at least structuring these deals in a way that will mitigate the type of risk that might come with a due on sale clause. So what we've been doing is utilizing a trust let me start here. Again, like we talked about, if you sell or alienate or transfer your interest in your property, they can trigger that due on sales and it becomes accelerate off something.
Can I just say one thing real quick? We started out with 101, then we went on a subject 2 and went to 2.0.
Yeah.
We're in like the 4,000 level.
Yeah,
we talked about these nuances here. So
yeah. Look, this isn't going to be the last time. Hopefully, you ask about it, right? Because we're happy to talk to you about it, and there's a lot to know and learn about it. But in the '80s, they set out this or legislated some federal regulation that said, "Look, hey, mortgage companies, we're good with due on sale clauses. However, you can't trigger a due on sale clause if the owner of a property transfers it into a living trust." Okay. Fine print there says transfer it to the living trust and occupancy and or rights of the property doesn't change, right? So, but nonetheless, on its face, if I have a piece of property that's subject to a mortgage and I put it into a trust, all right, which I have to record in the land records, all right, and so it's a revocable living trust, all right, of which, and every time you do that, the trust, you have to file an extract of trust. So a lot of states, it's called a certificate of trust. And you have to, say who's who. All right, I'm the settlor, I'm the person who set up the trust, I'm the trustee, I'm the beneficiary. Okay, that all goes into the record. It's all above board. Everything looks the way it's supposed to be. You've got the carve-out exception to the due on sale clause in effect. Okay, and then we credit sale the beneficial interest of that trust to the subject to buyer. So you're not selling the property, you're selling the beneficial interest, all right, of the trust, which owns the property. All right, so think of it in the context of going to an LLC, right? And this is another incredible tool, frankly, depending on, Mason and I were talking about this earlier, utilizing LLCs in creative financing deals and creative transactions where you're not selling the property, you're selling the LLC interest, right? So if I have a piece of property, I put it in an LLC, sometimes it might make more sense for a buyer to go get a refinance loan on a better terms, right, in the name of that LLC, then get a purchase loan, okay? And how you do that, you have to have seasoning that you mentioned earlier, okay? So I put a property in an LLC, wait 6 months, or if I have one available, I pull a shelf LLC that's been around for a long time, put it into that one, okay? And then backdate the deed, but anyway, nonetheless, and then I'm selling my interest in that LLC, right? So the LLC still owns the property. All I'm doing is selling the magical LLC interest that's invisible, but we all know it exists, okay? Same thing with the trust, all right? except it's a trust. The box, instead of it being an LLC that owns the property, the box is a trust, and I'm selling my beneficial interest in trust. I'm resigning as a trustee, and I'm appointed successor trustee in the buyer.
So that protects you on dual sale clause, right? Because
From what it looks,
that carve out allows for trusts, and we're now putting the property into a trust, which was carved out, and then we're selling the interest in that trust. So now the trust still owns that property. So
there's some nuance in there for sure, but that's the broad stroke on it, and that's just a risk mitigation method.
which we have tested, and we have actually executed contracts. This is not some theory that Joe has come up with. We've actually done this, and it has worked. And
It's good. It's a good tool.
we did it with a CPA who was very sophisticated in what she was doing and how she did her deal, so she understands a little bit about the trust work and the inner workings of that stuff. So she was comfortable with.
She was like excited about it.
Yeah, she was like, what?
Tell me more.
Yeah, like
But that wouldn't keep the mortgage company from foreclosing.
Well, I mean, if I look in the record, because you don't put the sale of the beneficial interest, that's not a document that belongs in the land record. The only document that goes in the land record is me transferring it into the trust and saying I'm the trustee, not the beneficiary.
To transfer to the trust, and then what happens to the mortgage company?
they
Get paid. So let's say, all right, Jared owns a piece of property. He puts it into a living trust. He's the beneficiary. I come and say, I'm going to give you $100,000. Let's just say that's the balance of your mortgage for your beneficial interest in that trust. I then become the sole beneficiary of that trust on a credit sale for $100,000, which I pay him by paying his mortgage.
Oh, okay.
Yeah. So it still has the subject to dynamic to us. Yeah. Yeah. Yep. Sorry. Yep. That's it.
Stacy line.
Yeah.
How popular is this seller financing when it comes to doing like commercial and multifamily real estate, like 5 units and higher? It's like maybe even built on the 30.
That's a good question. I had it asked earlier. What we tend to say, I remember the first time we got a big commercial deal, and it was a normal deal, but we were like, oh man, this was 2019. We got to go in, and we were like kind of nervous about it. It's like, it's the same thing. It's just the numbers different, right? It's the trajectory of the closing, the transaction is the same thing going from here to here. Now, it might open up doors of possibilities, frankly, to be more creative, because they might have entity structures in place that can allow you to do what we were just talking about with LLC interest, right? It might make borrowing a little bit easier. It might increase your marketability in that sense. From a fundamental perspective, it's the same, just dressed up in bigger numbers, right? And with the potential for greater capacity for being creative.
Are you in multifamily space? Is that what you're targeting?
I was starting to get into it. I've got a mentor. I've been doing some underwriting on multifamily commercial properties. He's actually an acquisitions manager for Disrupt Equity out of Texas, and they invest in like 125 units and larger.
Yeah.
And stuff. I passively invested with him, and he has a mentorship, so I got in with him, learn how he's doing.
Does he do? It's like a pooled investment or a syndication or
Syndication, joint ventures.
Yeah.
On size and deal.
yeah, and that's where you can get really into some interesting stuff on REITs and syndications and stuff. Which we're fortunate enough to have some clients in that sphere that do some. They're trying to get a $300 million syndication outfit right now. But I mean, like, whether or not that happens, you could kind of get into that sphere where things grow a little bit, right? The entities that you use are a little bit more complex, right? But fundamentally, it's always the same thing, right? It's always the same thing. When I'm putting money here to buy that thing, and I'm gonna get ROI,
And they pretty much all involve the buyer and the seller.
that's it. One of the things we did last year, a guy, and look, I can't harp this enough, and I have to say this because I wrote it down. One of the big reasons why we always, not the only reason, a big reason why we always encourage for you to put your properties into separate LLCs, okay, is not only for liability protection. All right, I have a house, all right, and I have it in one LLC, and I have another rental house, and I put it in the same LLC, and I do it again, and it's all in the same LLC. My exposure to liability grows every time I do that, because if someone slips and falls on house A, and all these houses are in the same LLC, LLC is going to get sued, and all those assets, right, could be exposed to the enforceability of a judgment. All right, so not only protect yourself from a liability standpoint, but you can create more opportunities for creative financing deals. What we did last year is a guy who we've told, I can't tell how many times, to please stop putting all your properties in one LLC. And he had like a, I don't know, $20 million portfolio.
120.
Yeah, way more, right? And he just wouldn't listen. He would come up with ideas as to why it would made sense to do it. And he wanted to sell a $5.5 million portion of that, right, on the West Bank. And the buyers, and we had a couple and suitors, and they were all wanting the approach of the refinance. Let me I'll become a member of your LLC, right? Or really, I'm just selling you the interest in my LLC. Well, clearly this guy couldn't make this man a member of the LLC because he's now exposed all the other assets to it, right? So you create more opportunity for yourself in implementing these types of entities, whether they're trust, LLCs, and they might seem like a headache, but I promise you, if you do it enough and you just look at it, it becomes clear and you see the forest for the trees, and it makes more sense to do it then.
Because of the seasoning issue, we couldn't transfer the yes out to a new LLC because the LLC didn't have enough seasoning.
And we thankfully had a shelf LLC that I had created and done nothing with like a year later. I mean, earlier.
How much you selling that for?
Well, the bill's still outstanding on it, but it's coming to call soon. Yeah, because they are not cheap.
Speaking of shelf corporations, I have a couple that I might be going to sell with you.
There you go.
Buyers.
Okay. No, look, I mean, that's great because, I mean, it was just like we were beating our heads against the wall, and I was just like, all right, Joe, I was hoping to say this because it's got a cool name for something else I was going to do, but I will sacrifice it for the sake of the deal. But because, I mean, yeah, they cost an arm and a leg, but that's good to know.
So as far as selling on a credit sale, what do I have to look at as far as Dodd-Frank?
There's something.
There's Dodd-Frank.
Well, I mean, when it's subject to it,
Or just a plain credit sale?
honestly, I mean, I don't know. You're not going to be regulated. You're not going to be subject to the same, regulations as banks, obviously, and those types of issues. There's usury, which you got to kind of keep an eye out for. But every time I've gone down the usury rabbit hole, which has turned into a million rabbit holes, it's not applicable, right, to this transaction because this person is not a licensed financial institution, XYZ. So I would say as long as you're not being abundantly or too usurious and any, just against public policy.
Against interest rate or anything like that?
Usury in Louisiana is what, 12 or 14? Well, it's probably gone up since the last time I looked at it. It's all right, yeah. But, 14, it might be 18 or something right now. But again, I mean, look, federal law would preempt usury. That's what they had to do back in the 80s anyway. Whenever interest rates went so high, well, if all states said usury is 10, but people were still getting 18% on their mortgages rate. So it's just a weird animal. I will say this, though. From a foreclosure standpoint, there's still a lot of regulatory stuff. If you are the creditor and you have to foreclose, there are a lot of I's and a lot of T's to dot in the foreclosure process, right? A lot of protections, fair debt collection practices, and things of that nature that you have to be wary of. And that's not to deter anyone from the credit sale thing, but it's just something to be mindful of as when you look at your remedies.
So when there was all that forbearance happening, were those subject to the credit sale between two individuals?
I don't think they would have been. Look, at that point in time, yeah. Could someone have made an argument, like in a district court judge in a state, just be like, I'm not touching it, and yeah, sure, we're going to stay it until we figure something out? Mm-hmm. That could theoretically happen, absolutely, right? Because again, I mean, I've seen judges really just get overwhelmed by introductions of things like that to where they'll say, I'm gonna not take a step without at least trying to figure out some stuff, and then depriving someone of what I might have otherwise unconstitutionally or regulatorily deprived them of. But other than like that nuanced kind of scenario, I don't think that would have been applicable. Yeah, because they're not regulated FDIC type of, right? It's not a government subsidized type of loan here, right? FHA, VA, or anything like that.
I don't know if y'all have anything else to add or kind of running a little over. Maybe have time for like one or two more questions, but yeah.
Let's take it high level real quick. Well, we're talking about selling finance,
The two main instruments would be lots of opinion or partisan.
Yes.
Okay.
Yeah.
Some other alternates.
Yeah.
With layers.
Yeah, with layers.
Structure.
Yeah.
That's generally where you would start.
Seller financing is like an onion.
Yeah, you got you got layers. To it. And I'll say this too. John, you're a real estate agent, right? You work for Keller Williams and
Work for Pelican Realty.
Pelican Realty. We got Keller in one point? No.
So
Pelican Realty.
Oh, yeah. Okay.
That's right.
Yeah.
A real estate agent, generally speaking, when you make an offer, you have to use the Louisiana buy-sell agreement. Generally speaking, I prefer the Louisiana buy-sell agreement in every scenario. It covers most of the bases that you have, and if you don't want to use it, just a provision, just don't use the provision in there, exclude it in the other terms and conditions. You can check the box on financing. It says owner financing. You can put the interest rate in the term and the other terms and conditions. You can put the balloon feature and indicate whether it's a buy or credit sale. You can do all that stuff. If you write a contract and you're trying to seller finance that deal and you want us to look at your contract, let me look at it. I'm perfectly happy to review it and make sure you got all the different things you need in there. So the amortized term, the balloon feature, how much is being put down, what the interest rate's going to be, whether there's going to be an escrow company involved, and whether the buyer or the seller is responsible for paying the taxes and the insurance. Those are the general things that we want to see to kind of get the ball rolling on that. And if you want us to take a look at your contract before, just like the pre-screen, send an email to us, give us a couple hours. Don't try to put us on a 15-minute time crunch because we have a few things going on.
We got a lot of 15 minutes.
Yes. But by the end of the day, one of us will likely get back to you and answer your question or your contract. John had a question real quick.
What's the best email to send?
I'm going to write my email address, and John's on that board right there. It's just Jared, Jared, and then John, John, as opposed to Jon, at arenacollective.com.
So just to cover yourself for things like due on sale clause when you're doing sub-twos, yeah. Do you have like a recommended amount of equity that you like to have in a deal, like just in case, or is that just kind of up to the buyer?
Probably just up to what kind of cash they have. Are you talking about as a buyer so that I can make sure that what are you going to do with the equity?
So basically, I mean, just in general, like if, let's say the home's worth $200,000 on the market and the seller's upside down, they're trying to get out of it quick. You take over, they've got $100,000 left on the mortgage, you take over $100,000. You don't want to give them the full other value of the house, right? Because then you could have just bought something in the market. Right. You have the interest rate advantage of the low interest rate, but you want to build some equity in there. How much?
That's up to your numbers.
Yeah.
I think you talk to Courtney or you talk to Steve, you're going to know what your box is before you even go into that deal, and you're going to scatter shot contracts. If you're doing it at a high level, from what I've seen these guys do, is they know what their box is. They can look on PropStream or wherever they look to see how much equity somebody has, and they're going to just carpet bomb a bunch of offers out based on this number of bedrooms, this number of bathrooms, this much square footage. They know how much work they'll have to do to a house in general. They'll know how much equity they want and how much they're willing to give up, and then they're just going to make a bunch of offers based on those factors in there, and it's very unemotional to them, and they're just going to send a bunch of contracts out. They send 100 contracts, they get 10 come back as signed. They got 10 new deals, right? You just got to know your numbers are and what you're comfortable with to get all assessing risk.
And that's probably going to change over time. I mean, the right idea
But I would say, yeah, I mean, whatever number you're comfortable with, I think more the better answer, because
we don't have, I'll say it this way, we don't have like statistical data that says like, this starting with this equity point is more successful than starting here or there, which would be interesting information to get.
Yeah, lyrics.
This gentleman asked about the commercial multifamily agents, and I was selling financing with applied to that job. And I was talking about but on the commercial side, is your offer for the pre-screen of title will apply to a commercial property as well?
Yeah. Bigger the number, the better, in our opinion. We make more money on the higher value deals. I'll take all of it all day. I'll pre-screen all of them for you.
Yeah, for real. I mean, look, if we get into the weeds on it, it's just like some crazy thing. We're going to say, give us a little bit of time to look at it. But we can get you a good prelim search, like a pretty early, or recent historical liens and stuff like that. But if it gets really hairy, then we'll let you know that and say, just give us whatever.
You didn't know you'd be trying to get us out of here.
Yeah.
Can I ask a question? Yeah. All right. I'm just kidding. I was just thinking about this while I was sitting here, and I just want to get short ideas. How many of y'all have closed several deals before? Raise your hand. How many of you guys have a preferred title company that you work with? You can raise your hand. It doesn't have to be me. I want to know from a few people, what is your favorite thing that title company does for you in that real estate transaction that makes you want to work with them? And I am literally asking this question so that I can just get ideas for us. So you seem like you've done a couple deals. What's your favorite thing your title company does?
Those really those tree loan screenings. Like,
Cool.
I know I can call them, they'll answer, and they'll get back to me quickly. Great. That's the big thing.
Who's your title company?
I use Winters right now.
Great. That's awesome. Winters does a great job. They have a great reputation for a long time. Anybody else want to throw out something for me?
The responsiveness.
Yeah.
Getting back to me right away. That's
And what's the right away?
applying as soon as I call.
Good.
That's the fun, you know.
Good.
But this is a company in Florida, so you're okay.
Yeah, and look, we do this. We do that as well. A lot of our clients know they can call me literally 24 hours a day, 7 days a week, and they take advantage of that, and they call me, and I answer the phone. Except for when I'm sitting in front of a room of people, I have about 30 text messages I got to get to. Anybody else? Another idea?
Good hair.
Yeah, look, we got that box checked. Check. What you got, buddy?
Yeah, I think the best ones for me are the ones that communicate, are very proactive, and send out the closing disclosure prior to the closing, so you don't tell it. There's just ones that companies that don't do that.
Yes.
Great. Cool. Anybody else?
I just have another question.
One more idea. One more idea. Nobody else has another idea?
The kind of what he said, like, I use Audubon, and they help me with any deal, any question, and I always have fun.
Good. Nice. That's awesome. Y'all all deserve that kind of stuff. All right, what you got, buddy?
Do y'all work strictly in the Louisiana area or particular area, or do you deal with other states also?
So we do anywhere in Louisiana, and we do Mississippi real estate transactions. Anything in Southwest Mississippi, we will actually sign in Slidell more than likely. Sometimes we'll go there and hire a notary to come notarize for us.
Part of a national network, though, with some title insurance companies set for commercial deals, but if not just commercial deals, where we can pipe people into other. We did one this
South Carolina deal, for example. We go to the past Florida. Yeah. So, all right, cool. Anybody else have another question before we wrap it up? All right, y'all. I got 3 shout outs real quick. 3 shout outs. First, Tyler is a partner of ours. He owns a company called Boss Move Pros. We actually pay commissions to our investors and our real estate agents and property managers. We help people get their home services turned on, which is internet, cable, security, and pest control. It's no charge to the buyer. We just help them get those things turned on in their house. And if one of you guys connects us with them, we have a link that will trigger us to let us know that you connected us, and we'll actually give you a commission for referring them to us. So if you're interested in making a little bit extra money on every deal by just connecting them with us, no charge to you, no charge to your buyer, talk to Tyler, Wall Street Pros. Lettuce Media is a media company that we own. We do a lot of listing videos for our clients. So if you go to Lettuce Media's Instagram page, Arena has posted one unique short form video every day we've been open, and it has helped our business explode. If you're not doing social media, you should. And if you have listings and you want a professional video done, we can help with that. If you like playing pickleball, come talk to this guy right here. He's got a pickleball group in New Orleans, the biggest one in the South. They're a bunch of great people. They have a lot of fun playing pickleball.
like the biggest pickleball, or
They might have the biggest pickleball too. They'll make it happen. But John's gonna do. They have a lot of fun. And I want to thank Cole for letting us come out.